All right.
Mixing them up.
Yeah, no, I was just looking at.
It
I
is
see too many of those.
7 o'clock. So I am going to go ahead and call the meeting to order. We are in a unique situation where we don't have any chair or anything from the last time that the BZA met, which was January 5th of 2022. So for the time being, as we adopt our bylaws and then as we appoint officers, I will run the beginning of the meeting. So if there are no strenuous objections to that, we can go ahead and get started. So we're going to begin the meeting. Oh, first off, I guess we need to do a roll call. Melissa, can you bring can you run the roll?
Yeah, sure. Brian.
Payne. Yeah, here.
Chase Spears.
Here.
Dan Clemens.
Here.
Peter Eam.
Here.
Terrence Allen.
Here.
Right, we have a quorum. With that, we'll move on to our new business, first of which would be the bylaw revisions. In the packet was provided to you a draft of the bylaws to adopt that would then govern the BZA, Board of Zoning Appeals, as we move forward. I would entertain the bylaws provide that the board shall annually elect chair, vice chair, secretary, use Robert's Rules of Order as general parliamentary guide, allow the Director of Community and Economic Development to serve as a supplemental presiding officer when needed, and maintain clear procedures for public meetings and official action. I would request a motion to repeal any prior adopted bylaws of the City of Lansing Board of Zoning Appeals and adopt the bylaws as presented.
Mr. Chair,
Yes.
I move that we adopt the bylaws as stated, and that it supersedes all previous bylaws in standing.
Second.
Second, third.
Okay. Hearing a motion and a second, do we have any discussion?
We get to look at what the current bylaws being adopted are.
That is an excellent question that I wish nobody had asked. Honestly, we are adopting these because I could not find record of them. So I would love to provide you the record of the BZA.
I'm not talking about what we're adopting right now.
What are we adopting today?
What are we adopting today?
Right.
Oh, that was provided as a draft in your packet. So pages 3 through 6 of the
Okay.
packet. Do you need a packet?
I would like a packet.
All right. Let me get you a copy of the packet. Actually, thank you. And we'll bring it up on the screen.
I've got new screens.
So, generally speaking, can you scroll back up to page number 3? So, generally speaking, we have the name and purpose.
Okay. Yeah. I read these.
Okay, perfect. Okay, so questions about discussion about the motion. We have a motion and a second. Okay, I'm actually just going to ask for a voice vote. So all those in favor, say aye.
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 All of those opposed, say nay. Okay, hearing none, the ayes have it. Moving on to the next item on the agenda, election of officers. So, in the bylaws we just adopted, we are appointing a chair and a vice chair to run the organization. Secretary will be myself or the Community and Economic Development Director in the future, or somebody that the director designates. In accordance with the bylaws and standard organizational procedures, we shall appoint the officers for the upcoming year. The officers, as stated in the bylaws, will be appointed on the first meeting of every calendar year. So, in light of that, I would I'd like to hear a motion to appoint. We'll go with the chairman first.
Make a
we'll-
motion. Let's see. I make a motion to appoint Mr. Clemens, Dan Clemens, as chair.
I second.
I accept.
Okay, accept. All those in favor. So we have a motion and a second. We need discussion, conversation. Is there other folks having just met each other about an hour ago?
We're good. We're
Is there-
good. There's enough. There's enough history here. We're good. Let's go ahead and vote. Make this thing go. Let's get it on.
Is there any other discussion? All right. Motion and a second is on the floor. Melissa, can you call the roll?
Brian Payne,
Aye.
Chase Spears,
Aye.
Dan Clemens,
Accept.
Peter Eam,
Yes. Aye.
Terrence Allen.
Aye.
Now we would.
Just FYI, it's okay to vote for yourself. I mean,
Aye.
Okay. And then I would, at this point, I guess I can turn the running of this over to the chairman. Unless you want me to finish up this agenda item.
At this point, we need to vote for a vice chair. Does anybody have any recommendations, nominations?
I'd like to make a nomination for Brian Payne, Mr. Brian Payne, to be the vice chair.
Mr.
Second.
Knight, do you accept?
Second.
We got a motion, a second, and acceptance. Are there any other nominations? Hearing none, call the roll.
All right. Brian Payne,
Aye.
Chase Spears,
Aye.
Dan Clemens,
Aye.
Peter Eam,
Aye.
Terrence Allen.
Aye.
Are there any conflicts or ex parte contacts to declare? Any declarations? Hearing none, moving on. Staff report.
We would actually, so agenda item number 3 on the agenda is actually the meeting minutes from January 5th, 2022, the last time the BCA met.
Abstain. It says abstain.
We needed to get them in the record somehow.
record
So
somehow.
this is
Okay.
how we are getting them in the record. I will actually turn this over to Mr.
We're all going to be abstain.
Mr. Robinson. What,
we turn over before.
So
You're
how-
not getting
the minutes.
minutes.
None of the
We were not
members of
seated.
the BZA were on the BZA in 2022.
well, if we don't have anybody, then we'll just have to, do it by this board. I mean, there's no other way to get them in. I mean,
Okay.
otherwise they're not in. They got to get them in somehow, and this
Right.
is the official way to do it, so.
I would entertain a motion to accept the minutes as printed since nobody here was present.
Second.
No, I entertain a motion.
Oh.
Okay. Mr. Payne moves.
Ready to do it?
Do I hear a second?
I did. Yeah. Second.
Second.
Call roll.
Brian Payne,
Yes.
Chase Spears,
Aye.
Dan Clemens,
Aye.
Peter Eam,
Yes. Aye.
Terrence Allen.
Aye.
Do we have a staff report?
Staff report was provided to you in the packet, but tonight the board has met primarily not to adopt bylaws or adopt minutes from a meeting that none of us were at, but to hear an administrative appeal of the interpretation of the Unified Development Ordinance Article 4.02, Section D.3.E, which regards the construction of accessory buildings in the city of Lansing. So the matter before the board tonight is this question: did staff err when staff issued a written statement that the standard steel panel, commonly referred to as agricultural panel or ag panel siding, cannot be utilized as an exterior finish for an accessory structure on a lot that does not use standard steel panel, ag panel, as a primary material on the primary structure. The regulation as written states this. A detached, so this is UDO 4.02, section D3E. So section 3 is detached building. Accessory buildings over 120 square feet shall meet the following. And this is the paragraph that is under consideration. Be constructed with materials, architectural details, and style in roof forms that are compatible with the principal structure. Any accessory building larger than 120 square feet not meeting this criteria shall meet the setback requirements for the principal structure. The applicant proposed to and submitted building plans to the city for an accessory building at 131 Ida Street, and this included the exterior finish listed as standard steel panel. The building plans were reviewed, and the building official and the director of community and economic development wrote that standard steel panel would not be constructed with materials and architectural details and styles and roof forms that would be compatible with the primary structure. So the siding does not meet or is not compatible with a residential structure in the city. That is the question at hand. That is my staff report. I stand open for questions. And Diana, can you pull up the staff report? So page number 10 on the packet. So yes, I stand open for questions. The applicant is also here for questions when you have them for him.
So the
Can I kind of interrupt real quick? Sorry to do so, but I just want to make sure. I know a lot of people are new here. I was talking to Mr. Mr. Clement. Sorry, that this is a quasi-judicial forum. It's basically the group is acting as a judge.
Mhm.
There can be when there's quote deliberations, it's almost like whether it's a bench trial or a jury trial, you can recuse yourself to have an actual executive hearing or executive session to have those private discussions. It's usually one of those exceptions in the rules because usually everything's done in public, but because of the nature of this type of hearing, it is quasi-judicial in function. Therefore, you can retire into private to have private discussions once it's quote evidence is submitted for review by the body. This is typically treated as I look at it more like a civil kind of case where Josh has already kind of went ahead and presented the city's side of at least its position. Mr. McNeil will get to put his on with any evidence that he has for consideration by the board. So then once both parties have quote rested their evidence, then you can deliberate without either taking any additional information, or you can ask questions if you have any additional things you need clarified, things of that nature. So just wanted to kind of put that out there and let you know what your function is. It's just not, like a city committee or city council that sits here and has to do everything in public. But because of the judicial function, you can actually retire and do it in private if you need be. So.
Okay. I have two questions, one for you and then one for you.
Yes,
The range, the scope of what our responsibility here, is it to look at the regulation as it's written and see if the regulation as written is equal to the statement that was made by the city with regard to this, or is it wider than that where we can determine whether or not the regulation is accurate?
If I understand your question correctly, what my understanding of this is that as a judge,
Yeah,
you get to look at what the regulation is, and
that is it.
You get to look at that and you get to interpret it based on the evidence that's presented, whether it's by the city or by the applicant. So you get to make the decisions as to how you interpret the facts and the evidence, quote, that's in evidence as it applies to, quote, our law, which is our regulations.
Right.
If there's, and again, that's totally your deliberations of what you decide on how you come up. If you don't know this, but the decision here is final for purposes of the city. However, an applicant, whether that's the city or the applicant can appeal this decision to district court level. So.
But the regulation is the regulation. We're not.
Regulation
That's
is
not
quote,
scenario.
the law. It's
Got
a
it.
statute that you read, you analyze as to the facts and what the evidence presented.
Good. Second question is to Josh.
Sir.
I'm looking at the regulation that was in the packet. The last sentence on that says any accessory building larger than 120 square feet not meeting this criteria shall meet the setback requirements for the principal structure. Is that correct?
Yes.
What is that? Sounds like that's an exception to everything that came before. Am I interpreting that correctly or not?
Well, I think here's where we get in this dilemma of quasi-judicial organization.
Okay.
Because Josh is going to be here and he's going to take the position of the city and what he believes the interpretation should be.
Okay.
So for him to, quote, tell you what it means is
Okay, no worries. I got it.
for you to decide.
got it.
As it applies to the fact.
That's what I was trying to get to.
Yeah.
That's the crux. I want to make sure I understand my role correctly, and I think I've got it now.
To follow up on what Mr. Robinson said, the action in review criteria set forth in 2.09 for the appeals of administrative decisions, which is what we're here for tonight, says the Board of Zoning Appeals shall grant the administrative official's decision a presumption of correctness, placing the burden of persuasion of error on the applicant.
Yep.
The appeal shall be sustained only upon written findings that the official was in error. In exercising the appeal power, the board shall have all the powers of the official from whom the appeal is taken, and the board may reverse or affirm wholly or partly, or may modify the decision being appealed. And then the Board of Zoning Appeals shall take an action on an appeal within a reasonable period of time after the application submittal, but in no case more than 60 days after receipt of complete application. So maybe that will help your question.
In my world, we call that basically a rebuttable presumption. The presumption is that the city acted in a correct manner, but you have to look at all the evidence and make a decision. So.
Okay. Thank you.
One last point of clarification or point of information. There we go. Point of information. This is also a public hearing item, so we will need to open a public hearing prior and close it prior to making a decision. So, are there?
Does the staff have any other?
I do not believe so. In the staff report, I referenced the city's position on this has been the position for a number of years through from my office, not just myself, not just the current building inspector, but predecessors as well. Referenced one email correspondence in the packet that demonstrated that interpretation for other people in the city. So, other than that, that is all I have.
Anybody else have questions for staff?
Are you quote, resting at this point?
I was going to
Yes.
say, are you rested
Yes.
your all right.
So I think that Mr. McNeil wants to present his case. So if you want, you can.
Which is the next talking point.
Yeah. So the applicant has some photos that he's going to go through. I don't know if those are marked. Well,
Yeah,
Mr. McNeil's
and the applicant.
his exhibit for the file, the official file, are marked. And
1 through 6, but we got one for every member of the board. Well, welcome, new board. I'm glad to see you.
Thanks.
I was a bit surprised about the packet, the GovWell system, where you say, hey, this is what my question is, and what I believe is the question to the board is totally different than the question that was presented to the board, which is, did the staff err when the staff issued a written statement that the standard steel panel, commonly referred to as ag panel, cannot be utilized as an exterior finish for an accessory structure? I don't think that's the question. The question to me is, what does the code say, and is it being interpreted properly by the staff? I mean, when you look up the word compatible, it doesn't say identical. It doesn't say it must match the specific architecture. It just has to be in compliance. And if you look at the pictures I'm showing you in the first picture, that's the shed that actually the shop that I'm proposing to build. The second picture is vertical batten boarding, which to me is overly compliant or compatible with vertical rib siding on a metal building. And then if the real issue is aesthetics from, hey, we don't want people to see a building that doesn't match yours, then you can look at the third picture, which is the view of my house from the street, which is 350 feet off of Ida. You can't even barely see my house. The structure would be on the left side of the house where that tree kind of splits, further back from my garage. So, I mean, to me, the code says compatible, not identical. And just because we've said in the past that we don't want any steel ag buildings, I don't understand that. I mean, if you try to get a shop built, there aren't a whole lot of people who want to build you a wooden shop. I mean, there's a lot of general contractors that build steel buildings for larger buildings, and this is a 30 by 40. Another exception is I'm on 10 acres, and I'm in the middle of the city. I understand that's not a typical residential lot. So to me, I think this is an exception that shouldn't be that tough to give. But again, I would say that compatible doesn't equal identical. The only thing that would be identical in this city to that we can't have an ag steel building anywhere is a barn dominium, and we don't have one that I know of in the city of Lansing. So basically what we've restricted the architectural capabilities of a barn would be to a barn dominium. That doesn't make sense to me. So that's why I'm appealing that decision, that it has to exactly match my house. I think this vertically ribbed building is pretty compatible with the vertically ribbed building of my home. And I'm matching the garage, I'm matching, the colors. It's going to look like my home from at least a distance. So that's what I'm appealing, and I'm requesting that you approve it. And I would be willing to answer any questions that you might have of me.
Are any of these pictures your home now?
This is my home.
Okay.
This is the proposed.
For the purpose of the minute,
Can I ask you, just so that I understand we don't normally do it this way, but this is like a record to being made if she's got to type it up. So if you're going to say, I'm looking at Exhibit 1.
Exhibit 1 is the shed building, the first page I gave you guys.
Yep.
Exhibit 2 is my home, which is the garage part of my home, but the rest of my home looks exactly like this, the ribbed. And then the third picture is from Ida Street looking back up my driveway to my house. The little shed on the right is somebody else's building on just next to my driveway. But. Is that good, Greg? Or we all right with that? All right. Any questions for me, gents? I mean, I'll also say that, being as a mayor and on the governing body, I know we've had folks come and ask for variances to the UDO, which we adopted. His predecessor was here when we adopted it. We knew it was a blanket kind of ordinance policy, but we used to have just tons of separate policies, as Melissa probably knows. And this one kind of covered everything. But we knew at that time we're going to have to adjust and make changes to it because it's kind of like taking Olathe and putting it over Lansing. It doesn't really match everything. And we've made changes along the way, including distances of driveway, gravel, concrete, hard concrete for sheds. We made an exception for somebody who had all gravel driveway, and then our ordinance said you had to have a concrete to put your shed on. And he was like, my whole driveway, my whole area is all gravel, and you're asking me to put a concrete structure on here. We said, yeah, we don't have to do that. So I know we've made those kind of changes as we've gone along.
So Tony, so the and really probably so what the staff has already determined in terms of compliance, there's really no issue with that. I mean, they're calling strikes and balls, and basically based off of what is being presented, it is not an error, a material error, at least from my standpoint, or administrative error that the staff has made on the denial of your request.
No, I think it's an interpretation of the current code. So the code says compatible, and in my view, they're interpreting that as identical. So in order for me to have a metal shed, I'd have to order board and batting metal instead of just ribbed metal. And that's about, $14K more just to have board and batting metal that looks the same from a distance as vertical metal. So, I mean, to me, compatible doesn't equal identical. And that's my argument. If you want it to be identical, then say that in the code. If not, if you say compatible, it just has to be compatible with your house. It's not the same as identical.
Yeah, I get that. I guess the thing is, it goes back to whether it's aesthetics, the intention behind the code. And you mentioned a couple of things that caught my mind. Here is the, we don't have barndominiums here. We don't have metal buildings inside of our spaces.
Right.
And at the same token, for residences, but this is basically a shop, is what you're just.
It's a 30 by 40 shop. It's not.
And you're making the argument that it's set back and that the compatibility from a distance, the aesthetic component to this is
right. I mean, currently the code is saying there are no steel buildings that you can have unless you have a barndominium, and that's what I'm saying. There are none. So if you build a barndominium, then you can have a metal shed. If not, you're not getting one. I mean, in the current code, which doesn't make sense to me. As long as it's compatible with your home, like I said,
I guess that's the question I would ask.
Yeah.
What is the compatibility between the two materials?
So I mean, if you look at that first picture, what I've tried to do is match both color and garage doors to my home, which to me, that's fairly compatible, at least from a distance. It's not a white or red barn with white garage doors. I'm trying to match it to my house, and to me, that's compatible. But that's a board decision, and I'm just here to, as a citizen, to plead my case.
I guess that's where my concern is. If it's supposed to be compatible to the primary building, there would be same build material.
I don't see compatible as meaning same. Compatible. I mean, it's a somewhat loose word. It's not a totally loose word. You'd have to, as Lewis said, at some point you have to close your mouth around an idea. But if it legally identical is one standard, compatible is an entirely different standard. A 1989 and a 1990 Chrysler Sebring, not the same vehicles, same colors. Maybe one's the LX and one's the EX. Generally compatible. I mean, when I look at this, I see very similar buildings. I understand they're different materials, but to me there's nothing here that screams incompatibility, because in general the spirit of the structure seem to align, simply different materials.
And that's kind of what I'm arguing, the difference between compatible and identical materials. I mean, if you look at the definition of compatible, it's able to exist or occur together without conflict. Well, that doesn't mean they have to be of the same material. It's just, do they conflict? Is it?
Well, and I guess then the conversation is ag steel compatible with batten board siding? Are they the same thing? You know, do they have the same aesthetic? Do they have the same look and feel? I mean, obviously, when you get into durability or anything like that, the source material, you know, there's going to be odds and ends on each side of that. But do they actually?
Well, I guess there's another question, and this one I'm going to toss back to Josh in terms of, talk to me about impact in terms of what are the things that when we think of ag steel and when we're looking at the material and the permutations that this could open up, just on the side. Granted, I'm not expecting this inside of a new development or anything, but I'm just trying to get a sensing, and this is probably the reason why, have we seen anything like this before within the confines of the city?
So this is a question that gets presented to staff, specifically the building inspector, on, if not a weekly request, easily a monthly, where somebody, and that, again, one of the reasons I included a redacted email was to demonstrate that this is prevalent and has been asked before and will be asked in the future. The interpretation of staff has been that ag panel steel has a very unique look to it that does not fit in a residential area. The regulation written as such was designed to prevent somebody from erecting a 20 by 30, I hate to use brand names, but Morton building in the Maples, if their lot allowed it, right, size-wise. We have heard from a number of individuals who have come and asked, can we erect an ag shop in Lansing at these locations? And the answer has been, with ag panel, no. We are ambivalent towards the material type. If it is metal and you can, like metal roofs, metal siding, that's fine. But it needs to match the residential character of the existing, and that's where it comes down to be constructed with materials, architectural details, and style. And that's where that hangs on.
And that's where I'm kind of getting it as well. With the batten board style, it doesn't match a steel panel barn.
Well, and to Mr. M's point, and I'm glad you brought it up, because I was going to, when we saw, we did not receive packets, to be clear. They were posted. We went and looked at them. And I saw, okay, this is about a shed, so I want to educate myself. I did a little bit of driving around. And it just so happened, my wife and I were in this room in February of 2025 when this very topic came up with another resident of the city about building sheds, how the city had denied him a permit to build a very similar shed to this. And so he went the traditional siding route, and simultaneous to him being rejected, his neighbor was approved for a steel panel building, and I got curious, and so I did drive past it. I wanted to visualize this and see, okay, like what, to get a better understanding, what does the city usually allow, not allow, so I can come in here hopefully more educated. And I must say, and this is no slam on the other resident of Lansing, I must say this is a much more architecturally aligned to housing steel building than the other steel building that the city did allow. Now they may, and Josh may back and forth with me about the type of steel that was used, and that's a fair debate to have. But when I think in terms of what is compatible with the style of the neighborhood, with the style of a residential place, I will tell you, gentlemen, from what my own eyes saw, this is leaps above visually more compatible with residential than the building that I looked at with my own eyes on Gilman, that the city approved that the owner did not have to come in here with, which does give me some pause about, are we being capricious in terms of how we're interpreting that rule, and why I think it's very important to remember it's very very deliberate that the wording is not identical. Right? If the city council, the elected city council, wanted it to be identical as our representatives, they're intelligent men. You sat here. I think if you wanted it to,
I voted on it.
I think if you wanted it to be identical, sir, you would have said it very clearly. You know the difference between identical and compatible.
Yeah, I mean,
Is that a question to me?
No, I was saying.
I'd like to just say too that, like, it has to be compatible. But when I asked, okay, so if I have to go board and batting, then do I have to go? I mean, I meant board and batting, like put wood up, do all that. Do I need, to match the roof, my asphalt tile roof or whatever it is? And they're like, no, that could be a metal ribbed roof. And I'm like, okay, so why can the roof be metal but the sides can't be metal? I don't understand the code part of that. In my view, that was the answer from the code enforcement folks. I was kind of like, okay, that makes no sense. If you're going to make me do board and batting, why can't I put up a metal roof on it? So that's why I was saying compatible doesn't equal identical in my view. It's just they're not making sense.
I think the piece I want to kind of explore a little bit more, though, is and I think the compatible is a good discussion. But I think there's a second piece to this. That last sentence on this is any accessory building larger than 120 square feet, which 30 by 40 would be bigger than 120 square feet.
Yeah.
Not meeting this criteria shall meet the setback requirements for the principal structure.
Right. So, I mean, to me, and I think you had a question on that early on, right? Weren't you asked Josh about that? But I mean, so to me, this is a difference of 40 feet, maybe, from where I was going to build it along my garage. I'd have to meet all of the current codes according to the, can't be a metal structure or whatever. But if I put it behind the sight line of my house, I don't have to follow those. And that's how the code reads currently. So for me, that's an additional 45 feet of gravel and concrete that I got to put in, right? I mean, I can do that, and if your guys' decision tonight that says, this isn't compatible, then I'll do that. I mean, I'll put it behind the sight line of my house, and I'll put up the same metal structure that I'm going to build here.
Okay, so you can this isn't a matter of whether or not you're going to be able to have this building or not, or it's not going to be the same.
That's how I interpret
what I just
the
heard
code.
you say is you're going to end up building this back further on your property.
Right. And I mean, that's kind of why I put that third one in here, because that's what you can see anyway. So, I mean, if it's an aesthetics thing, you're not going to see it whether it's 40 feet further back or, 40 feet closer to the street.
And so your argument, I completely understand the aesthetics of it at all. I'm still building. It looks great. The building that you're looking at looks like a great shop. I'm envious. But that's an opinion. The spec is the spec, and like I said, I know that it's compatible, and I know that's your arguing point for where it doesn't meet. But I guess as someone, I've read a lot of spec, and that is pretty boilerplate. It has to be compatible, and if it's not compatible, in what ways can he demonstrate that it is? And in this situation where it's, to me, like I said, to me it's stated that it has to match the primary residence in compatibility. So incompatibility to me means it would need to be a wooden structure because the primary structure is a wooden structure. And then it's a great arguing point when it comes to the metal roof, but we're not here on that. We're here on the primary structure. We're here on the siding of the building is really what we're here for.
That's what I'm still kind of spinning around a little bit. Is it's the siding, and it's also this issue of, again, the aesthetics is what's continually running around in my head, and I think the other issue though is, the nature of the terrain that you are on, the land that you are on, and that the neighborhood itself is sort of a hodgepodge of different things. It's a little bit. If this were out in a rural area, I don't think we would even have this conversation at all.
I'd be in the county. I wouldn't have to come to.
And so, but I think that also kind of goes back to the different point about how we're looking at code inside of inside of Lansing proper,
Right.
And that's sort of where I'm. That's why I was asking the question about what the potential impact is. How many other 10-acre pieces of property with woodline do we have?
They're not. So when I get assessed for property taxes, they take me out to the county and say, this is a 10-acre estate out here. Well, that's great, but they're not paying city taxes at the same time. That's why I showed that last picture. It's kind of like, if this is an aesthetics issue, you're not going to see the barn. I mean, or the shop. If it's a strict code issue in the city of Lansing, we're never having a metal building, because right now you're not. There's no metal building home structures that I'm aware of, right? So if somebody builds a barnuminium, they're the only guys who can have one of these metal ribbed ag buildings, which to me doesn't make a whole lot of sense. But
And yet somehow there still are metal buildings in.
there's plenty of them. But
I went.
I'm just saying, based on the code,
Right.
the only structure that is, quote, compatible would be a metal home.
Yeah.
And there's just, if you want to build a, 30 by 40 shop out of wood,
Exactly.
it's insane, the
Yeah.
cost. It's almost double, to be honest
We're
with
not
you.
here to look at the cost.
And no, I know that's not your decision, but I'm saying when you make a decision,
Yeah.
that's kind of what the impact is on everybody else too. So
So for me, I think there's a couple things that are in tension with each other. There's the aesthetics, and you've got a nice building here that seems like it would match up with the house fairly well. But then there's the precedent, and your situation may not be the same as the next person that's also going to apply for a metal building, and so we've got to look at that as well. So there's kind of this. That's why the regulation is written the way it is, and that's why I keep going back to the regulation the way it's written, because I really want to make sure I understand the regulation correctly, because that, I think, is the real crux of this whole thing. It's not about how I feel about it, it's what did the regulations say.
Right.
And that's why I want to get into this. Any accessory building larger than 120 feet, not meeting this criteria, which means anything that was written before, shall meet the setback requirements for the principal structure. What's the setback requirement for the principal structure?
it's the back line of my home. Is that not
Well,
right?
what,
Josh?
is it 300 feet? Is it 100?
It's not. So the principal structure
Is the home?
Yes. So the setback requirements would be delineated in the table 4.1 or 4-1, which is your front. I believe he's R2. The front line is 15 feet. You got 5 feet setback or interior line setbacks, and then 15 on the rear. So that's the setback requirements for the principal structure.
All right, can you translate that in English for us?
From your property line, 15 feet from the front line.
From the front of the property line.
Yes. The 15 feet from the rear of the line and 5 feet from the sides.
So 15 feet from the rear of his property line and 5 feet from the side.
Correct.
Anything anywhere else, as long as he doesn't put it any further than the front of his house, is good.
So this gets into the question at hand.
This gets into the acreage that I'm on in a regular subdivision, which would be a front line cut that you would easily.
Because it seems to me 300 feet back from the road
Yeah, I'm already.
sounds setback to me from a mind that doesn't do this daily. And that's why I'm asking the question.
So yeah, no, it's a good question. again, this is why the BZA exists, right? Like, not everything applies. And we have a counselor, or we have a multitude of counselors here to figure this one out. The purpose of the regulation was to keep agricultural steel buildings out of residential, specifically residential neighborhoods. This accessory buildings apply not just to residential properties, though, right? So that has been the case. That's how we've interpreted it. That's how we've enforced it. To the point made earlier, again, we have told dozens of people a year, yes, you have to go. You might need to go build a wood structure. Dan has gotten pretty good at having that conversation. But in regards to the setback requirements listed there, traditionally we've not ran into a property that would have capacity to do that.
Right.
Putting a 30-foot building on a 70-foot lot probably doesn't work very well.
Exactly. So
So-
what I'm getting, the regulation as it's written, I
Yes.
understand there's an intent, but as it's written,
Yes.
there's possibility. That's what I'm trying to figure out. Is this regulation is written, does it prevent him from building his building?
The reason we are sitting here tonight is that we said yes, it does.
Oh, well, I mean, the way I read the reg, it doesn't, right? So, I mean, if you say no tonight, I have sets of flags that go behind my property and sets of flags that line up with the back of my garage. And in my view, when the decision is made tonight, pro or con, I'm either having that guy come and build a pad on those back flags or on the front flags. So, I mean, it's going to be an ag steel building behind the sight line or along my garage line, or right behind my garage line, which is where you can build a shop or a shed. So
I just want to dig it. I got you, but I want to go back. I understand the intent of the law, but the letter of the law,
Sure.
as it's written right here, is he allowed to build his building or not?
That's a decision you
That's hard.
Okay.
oh,
And
You understand there's obviously two
well, he's
competing
asking two questions, though.
What I'm getting at is I'd really like. Is it possible for us to pull the overhead of this of the property and put it on the screen for a little bit,
Yeah.
Sure.
and so we can see where this is where this building is going in relation to the.
And I do want to ask, I'm sorry, I'm not trying to cut you off, Brian. I just want to get this out of my head before it leaves. Is if Josh is saying the intent of the law is to keep steel buildings out of Lansing, I think that is the determination for the city
No,
council to
that's-
make and put it in writing.
That
And that's-
I would strongly ask you to reconsider what you said. There is nothing that prohibits a steel building being used in a residential district in the city of Lansing.
Except there are no residential buildings that are steel.
But-
I mean,
But
that's
you
there's.
can build, and you can put a steel building on your property in a residential district, as long as it meets, be constructed with materials, architectural details, and style, and roof forms that match the principal structure.
But a moment ago, you said the intent of it is to keep.
Ag panel steel buildings, yes. But not all steel buildings are ag panel steel buildings, which is why there is a
Right.
profile provided in the packet of the ag panel steel with the board and batten,
Mhm.
right? So, Diana, thank you.
So is this question of, does his panel equivalent to an ag panel, or has technology changed where it's no longer? an
That
ag
gets
panel?
into
It's ag panel. It just looks like board and batten. I mean, it's ag panel with the square board and batting versus ribbed. I mean, it's how they form the metal. Ag panel. I don't think the constructors of those buildings call it ag panel. I mean, they just call it a metal building.
Steel building. Yeah.
So to say that we don't want any ag panel, I don't. If we say we don't want any steel buildings that in the city,
That's real. All we gotta do is look at the regulation. I don't care what the intents were because I don't know what the intents were. The people who wrote whatever they wrote didn't
Right.
tell us what their intent was. They just wrote the law.
yes,
So let's play with the law. The law says that you've got setbacks. That's your house.
yes.
Where's this building going?
So it's going to go just above the, right there, where the back of my garage is.
And what's in the
along that line,
okay?
or it will go down here further along the line
Okay.
back behind the house.
All right. And what is the setback from where you were talking about putting it at in the first place?
Well, the setback typically
you-
to build a
You're clearly
a
further.
shed or a shop, you can go behind the line of your garage. So that's the first line is this garage line. The second line would be behind the line of the house.
Mhm.
And I'm, like I said,
But where you're putting it at, it's well forward of 15 feet of the back property line,
Look, yeah, most
the
definitely.
property
Okay.
line's
Down here, just like
and it's well within 5 feet of any of your boundary lines.
Yeah.
Okay.
I mean,
When the
so-
property on Gilman came up to the city council, what was the final decision?
Well, that night, the decision had already been made, and the petitioner was coming to just register his displeasure and to ask the city council to take a closer look at making sure that the laws were applied, the zoning regulations were applied fairly going forth. But I don't know if the city council took that up or if that went before the planning commission or not. But it was he had already been told this is what you have to do. He'd already spent the money, but he was coming to say, hey, look, you guys told me I could not do metal building, and immediately afterwards, my neighbor built a much larger metal building.
So he was asking for consistency.
He was asking for consistency, and I drove by and looked, and the metal building that is there appears visually from me imagining the scale of this to be significantly larger than this, and looks much less homely than this. And that's not a hit on the
But is
homeowner.
is it behind the house?
It is behind the house.
Then
On a much smaller lot that is plainly visible from the road. It's the tallest structure on the street.
We can also compare other cases to this case.
No, I mean precedent matters.
I think that's the point, though, is if we have precedents of metal buildings being erected on other lots that have been here before, and then, okay, we have those, but then we're looking at this particular case. So a couple things that jump out in sightline, aesthetics that are like visible, right, in terms of the impact that it has. And then in terms of like, okay, now I'm getting inside the material piece, which isn't really a thing, because again, it's just the material is not necessarily a thing. What the real issue is we don't want a certain type of structure, that's probably more suited for rural or something that is looking that way. Whereas it looks like, at least from what I can tell, the design of this is looking as much as it can to comport with what his base structure is what it seems to me.
If I may pose, not to cross-examine, if I may pose a question to the city, one, and I know as Director of Economic Development, your role is heavily focused on how do we make Lansing more economically viable. And I see in this case a landowner who's wanting to spend his own time, his own dime, to enhance the value of his property, which is to the benefit of the neighbors, the benefit to his lot, which is long-term to the benefit of the city in terms of tax collections. He's not asking for.
Just going to increase my property taxes? No.
I've been in this room many other times when out-of-towners are coming and talking about developing and asking us to help fund them doing it. He's not doing that. And so my question is, what does the city and what does the neighborhood lose with this?
The city loses a position that we have taken for a while because we, in the development of the code, as far as I am aware, there is discussions about the general look and feel of neighborhoods, and it is always a concern of residents about what types of buildings that are going to go up in their neighborhood. And so this was put in there to help give the city some guidance in regulating, not giving interpretive license within how this is written. There are other cities that would say just outright no metal, right? In residential areas. In our commercial standards, there is a list of prohibited materials. You may not build commercial buildings with these materials. There was license given for interpretation on what compatible means within whatever context an accessory building is built within Lansing. By saying that staff's interpretation of this regulation is wrong, we would be losing the ability to prohibit a 20 by 30 or 20 by 20 ag panel building being constructed in the Maples or in a subdivision that there are odd parcels in which they could fit, and people look for those odd parcels to be able to go and erect extra garages or something to that effect. So that is what we would be losing, the ability to continue to enforce that interpretation.
So just thought. In his situation, it's fairly unique. However, there are other places where that uniqueness might also apply. It appears that the uniqueness of this, I don't think that I'm not going to say that, but what I'll say is I think that the general trend of how we respond to this is correct. I think we're right in reading the regulation.
Okay.
But there might be places where the regulation as it's written has given a loophole. And it would only apply to a very, very small number of people. So you wouldn't have to go back and relitigate or read anything out for people in the past because they would not fit the criteria of what this says. Secondly, it sounds like something that should come to the zoning board for refinement fairly quickly so that we can get that straightened up and make it very, very clear.
In light of that, I don't know if this is appropriate for this context, but I'll say it anyway. The member of the Planning Commission who sits on the Board of Zoning
That's what I'm saying.
has an opportunity tomorrow
Yes.
during the conversation after
Yes.
to say, hey, staff.
Post decision, I hope.
But to Brian's point, I think Brian, you hit the right point though. Is I think that the city is spot on.
Yes.
In the interpretation of the regulation, I have no doubt about that at all. But I think that I think that in terms of what we're trying to do, again, when we're looking at, relax, Tony, don't worry, but the real factor that's at play in asking for a variance, the mitigating things that are here is sight line, the compatibility of the design, the things that are unique to this condition or this appeal, which again, I think on the appeal, there's nothing that administratively, you guys got it. You're calling strikes and balls and you called the strike. But I think what we really have here, though, is something to go back to what Brian just mentioned, is this is something that when we talk about zoning and we're talking about the things that are embedded, because I think that you can still, just again, looking at the pictures and just kind of listening to the arguments, this is what helps us get better regulations. I think it lets us have a little bit more refinement in what we're dealing with. I also think that if we set a precedent, at least we've got a good precedent to base it off of, which is this 10-acre lot that has this type of conditions that are being established. And at the end of the day, I could give two hoots whether it's metal or wood, in terms of the material. Even you had stated that. And I think that's where, again, it doesn't undermine what the city is stating. The city is still calling it strikes and ball in terms of, in this word, compatible. Right? That's just my 2
But
cents.
it does bring in, the ordinance does say style as well, right?
Style.
And I think that's, honestly, Tony, that's where I'm kind of locked in at, because if you look at black and white, it says style, so the building should match the style of the primary residence.
Yeah, and so if you have a brick building, you're going to have a brick.
Right.
To me, that doesn't make a lot of sense. If I'm going to put up a shop, I don't want a brick shop. Just because it matches my house. You know what I mean? To me, that's what the code's saying. And to me, at least how they're interpreting it. Compatibility might be different. That's why I said it's, the term compatibility does not mean identical, and it doesn't mean the same exact architecture. It doesn't mean the same materials. And the fact that they put in the back, if it doesn't meet those materials, well, then just put it behind the sight line of your house, which tells me this is a residential lot. We don't want to see it. Okay, which is why I put the third picture in there. Was you're not going to see this anyways, no matter where you're from.
But all that, I appreciate it.
Yeah.
But all that really is irrelevant. It's what does the law say, and what the law.
Well,
and what
the
law
code says compatible, and that isn't irrelevant, Brian.
Let's go to the last sentence of what it says.
Okay.
The last sentence says, if it's not going to meet the, I don't see it.
If it's not compatible, right, then it has to be behind the sight line of the house.
No, it doesn't. It says it has to meet the same setback as the home.
Okay. Yeah.
Which is 15 feet off the back property line, within 5 feet of any sideline, right?
Yep.
That means you can put that building wherever you want to. Is how I'm interpreting that right now. So that's if I'm reading that law correctly, that's the exception to everything that came before. So everything before that we keep talking about compatible style, everything else, that's that part of the law. The last sentence is the exception to everything that was said before.
Correct.
So my point is, the city is absolutely correct in saying what they did with regard to how they interpret the law. The exception that's in there is only going to be an exception for very, very rare occasions. And you may be one of them.
Might be one of them.
Yeah.
Well, the exception, yes. The exception is you can't stop me from building it because the code says blank, right? I'm appealing that, right? That's the bottom line is based on the law. If you build it behind the sight line of your house, you can build whatever you want,
yes.
Right? In any kind of crazy structure. I'm coming to say, hey, I'd like to build this nice one that I say is compatible. The law says identical, at least how it's being interpreted, in my view, to materials. And that's what I'm appealing.
But it seems like your building meets the exception, is what I'm trying to say.
I do think.
If you think about the,
And
if you think about the mechanics of your property, which is very unique, and what the law says, you may have an exception off of the way it's written. What I think I would recommend possibly, an option might be to apply for an exception to the variance, in which someone comes out and looks at your property, or we can look at it now possibly, and potentially give an exception to variance so that you are a rare case. The city has not made a mistake, but they have rectified that your property is unique to the law as it's written.
Exception, or fits the.
And
I
that's
mean,
how.
which is what I'm appealing, right? Or, yeah, I'm asking for an exception to that. So, I mean, like I said, that's what I'm appealing. You've seen it in there.
Now, tomorrow there's going to be a discussion about what this law should say. I'm just going to tell you. So I would you better move fast.
I'm with you.
So
I'll pay my fee in the morning, and then you guys will meet in the afternoon, and then I'll get the permit. Okay, that's all I have. Unless you guys
Mr.
have any
Chairman,
more questions for me.
At some point, I guess I know there's been questions and answers back and forth, which is kind of
We
the
need to
evidentiary
deliberate.
phase. If you're at a point where you're now done with evidence, or if you want like the final summation of the positions, then you can close the evidence quote, so to speak, or close it, let them make their final argument, then you guys can confer and decide what you want to do.
okay.
And
we
hold
have
the
to do
public
public
hearing.
hearing.
We still
And
have,
hold
we
the
still
public
have to
hearing.
have the
We have to
public hearing.
close it.
Are you done?
We got to open the public hearing.
Oh, I thought I was public. I'm just, okay.
No, you
Anybody
were,
else want to speak?
you were presenting your case.
Okay.
Okay.
All right.
I'm closing my case. Thank you, gentlemen.
Thank you,
All
sir.
right.
Thank you, sir.
This is a public hearing. We're going to need a motion to open the public hearing.
I make a motion to open the public hearing.
I second.
All vote?
Brian Payne,
Yes.
Chase Spears,
Yes.
Dan Clemens,
Yes.
Peter Eam,
Yes.
Terrence Allen.
Yes.
At this point, we'll hear anybody that wants to speak in favor of. I know you've been up here for a while. We know you're for it. Are there any others that want to speak for it? Are there anybody present that wants to speak against it? Not hearing anybody. I hear a motion to close the public hearing.
I make a motion to close public hearing.
Second.
Call the vote.
Brian Payne,
Yes.
Chase Spears,
Yes.
Dan Clemens,
Yes.
Peter Eam,
Yes.
Terrence Allen.
Yes.
All right. Do we?
Just point of information that has nothing procedural on things like this. I would suggest that the Board of Zoning Appeals adopts voice votes for things like opening and closing hearings. Anyway, so sorry. That's point of information.
That would be fine with me. All right, so do you have a motion on how we're going to move forward?
I make a motion that I would like to have a quiet or a small group discussion and deliberation before doing any vote.
Second.
Let's have an executive session.
You have to say what time you're going out, what time you're coming back.
Yes, sir.
I'm just letting you know, that's
How long do you guys want? Do you guys
I don't
want
think
10 minutes,
Do we need more
Is that-
than 10 minutes?
or do you need 5?
Just so you
Or
know,
7.
you can't come back early. So whatever time you say you're coming back, that's the time you come back.
Do we need more than 5?
So let's go 15.
I don't know. It depends on what everybody says.
Well, you can always,
I'd say-
well, when you come back, if you need more
Yeah,
time.
we can always come back
Well,
more
Come back, say
time. So
more.
let's
Yeah, you
Okay.
can go back and do it
Let's
again.
start with 5. Let's start with 5. 10.
Okay, so let's go to
10?
the executive session for 5 minutes,
5 minutes.
starting at 8:10. We'll be back at 8:15.
Second.
You got to vote.
Second.
Voice vote.
Okay.
Second.
All those in favor?
Aye.
Any, yeah.
10 more minutes.
Well, you have to come back in.
We have to come back in.
That's all right.
We need to open or close the executive session. Do I hear a motion to close the executive session?
Yes. A motion to close the executive session.
Second.
A voice vote?
Aye.
We need,
I'd like to make a motion to open a second executive session, this time for 10 minutes.
Second.
Starting at
8:17.
8:17, coming back at 8:27.
8:27. Motion? Have a
Aye.
second?
Aye.
All in favor?
Aye.
I'll get it, Josh.
All right.
They just got, so it's kind of funny when they say,
3 seconds to spare. Do I hear a motion
rule
to
by,
close the executive session?
I motion to close the executive session.
Second.
All in favor?
Aye.
Who seconded?
I did.
Okay. I didn't
I-
hear that. I didn't really hear it.
Chasing the
No decisions were made in the executive session. Do I hear a motion in this case?
I would like to make a motion that we table this issue to a later date, and also refer this to the Planning Commission.
This is your day in court. There's nobody to refer it to. This body is the judge.
Got it. Then I guess we're not ready to make a decision. Here's what I'm going to ask you. We have the option to table this.
Well, I've never had that question asked of me, and off the top of my head, I'm going to say no.
We asked during training if tabling is an option.
What's that?
Is tabling it an option?
For BZA judicial,
I also said that is there's good questions for the attorney to ask to the attorney.
I don't know. That's a question of, in my world, we call a question of first impression for me. I've never ever had a BZA where
We
someone
think
could make a
it's
decision.
more appropriate as an
Exception to variance.
acceptance to variance than it is an administrative appeal. We
Well,
think
that-
it's being
well,
brought
that may
up by
be
the
the
wrong
case.
court.
But the question presented to, quote, the judge is whether or not whichever case is presented and which is the judge is going to rule. Either it's
Yes.
city's correct or the applicant is correct.
And if we
Yes.
table the case, this case,
Finish it up. I'm sorry.
then there's an opportunity for people to take actions that would not require it to be brought up again in the future. And it could be brought up, that could close this out, and then we could fix the law in the Planning Commission.
Well, but
So you're going to push us into somebody saying is wrong or not in order to get to the right solution. Or we can get to the right solution and not have to do that.
Well, usually the way this works is it's kind of like the admonition to a quote fact finder is that you should not take into consideration that another day there be either more evidence
Okay.
or more
All right.
anything
Okay.
else to make a better decision. So the evidence from both parties has been presented. It's
Fine,
not-
I'll make a motion.
Okay, it's not
I'm
going
going
to
to
get
make
any better.
I'm going to make a motion that the city made an error in the way they interpret the regulations. They did not read the exception clause of that last piece of that correctly, and therefore they should have granted this to this gentleman for his building.
Do I hear a second?
Second.
Who seconded? I'm sorry.
I did.
All those
I'm sorry.
in agreement?
This one we should do a by name vote.
All right, Brian Payne,
Yes.
Chase Spears,
Yes.
Dan Clemens,
Yes.
Peter Eam,
Yes.
Terrence Allen.
Yes.
One thing I would also, there will have to be a written decision. I presume, Mr. Clemens, you've been by accepting your position, understand you'll write that. Is that correct? Okay. What I would ask is, I don't know what was discussed in your executive session to make your decision, but in your finding, I would ask you to kind of detail what the issues were and why you came to that conclusion.
The law is
issue
clear.
was the acceptance of, the last paragraph wasn't out, and that we don't think that was sufficiently considered in the staff's determination. They weren't wrong; it just wasn't considered.
Then all I ask you to do is in your decision that you set forth why you came to this conclusion. That's it. Because then the city has to determine whether or not they believe that they should appeal that issue. And we just need a basis for what, I'm not saying you're right or wrong. I mean, it's your decision. What I'm just saying is that if a party wants to appeal something to, let's say, district court, we just need a reason why the body came to its conclusion. That's all. Basically finding a fact.
All we did was regurgitate
we read your law.
in private what we had said in public, and got everyone else's feelings up here.
And again, that's fine. I mean, I can accept what you're saying. All I'm saying is that that a written finding, I think you already mentioned, maybe I misunderstood, but did you say earlier whenever the decision, there has to be a written finding submitted for the file, so we know what it is, and the party.
So you want me to write an email?
Well, if you want to do an email, if you want to do a memo, I don't care which. It's just, so we have something in writing, and you may.
I'll be glad to draft it for you.
And that's fine. I don't care who drafts it, but if Mr. Clemens, you're chairman, if you don't mind having it for his signature, that's fine. So.
Not a problem.
So, but just so, as we're building the minutes and understanding that you found that the staff administrative official erred by failing to look at all of paragraph E of the
That's
section.
correct. The last sentence
To apply,
of
to apply that.
the last sentence of that law of that piece that's written. When you look at that piece of property in his construction site, the construction site fits well within the regulation as it's written right now.
His property is unique among itself, and that same argument cannot be applied to all the others.
And so it clearly is a statutory interpretation, is that, just so nobody goes away kind of quote with hurt feelings, 'cause I do this for a living every day. And what I'm understanding is that, but for a nuance in the ordinance regulation itself,
if the last
city's
sentence,
decision, but for that last bit,
if the last sentence had not been part of the rule, you would have been 100% correct. But there was an exception written into the law that we did not follow.
And if there was discussion, again, I wasn't part of the discussion, but if there was, and if there was the discussion about those type of variance things, even though we understand this was not a variance action, but I understood there were some comments made in reference to this being a 10-acre lot, this being somewhat different than a postage stamp
This is
residential lot.
it's a very unique situation, and the exception that's written into the law as it's written, it's probably written there for this very reason. I wasn't there, I didn't write it there, but that's the reason why it's there, because this property is big enough that variance piece, or not the setback piece that's at the last sentence, will not apply to most places.
Right, and again,
that's why we
I'm
were
not quibbling with
that's
the
why
decision.
we didn't want to say the city did something wrong, but they did.
All I'm getting at is that the more detailed you are in the reason you come to that conclusion, what I'm asking is basically so that, because what I'm hearing from this body is this seemed to be an exception, not the rule, and with the language, what I'm getting at is, so
yes,
and that's fine, but from the city's position, for Josh's position, as he kind of stated, I don't want somebody coming in with a lot the size of this, coming in and saying, we got a steel building now because of this.
No, it can't, because the law, as it's written, would exclude them from that.
And that's fine. I'm just saying, set forth in the
Boy, it sure would have been nice if there was a variance to exception approved tomorrow morning, and we didn't have to have this discussion. But we couldn't do that.
So, thank you for the clarification. Gentlemen, thank you for your time.
You want to war and peace now?
I think we probably need to adjourn.
We do need to adjourn. So, but I just wanted to say from staff, I appreciate you guys being here. Thank you for the way forward, the conversation. This has been, I'll be honest, much longer than I expected, but a good conversation, and I appreciate you guys making that determination and giving up your time to hear the city and the applicant. So, thank you for that. And with that, I will turn it back over to the chair.
Sir, I make a motion, we adjourn.
Do I hear a second?
Second.
All in favor?
Aye.
Aye.
All opposed? Go home.